the person violates their probation or is deemed to have violated their probation by the probation officer who's supervising them, then the probation officer would file what's called a petition to revoke probation, or a PTR. And that document is very similar to a complaint in that it's a document that the officer, the probation officer, is filing with the court to put the court on notice that they are accusing the defendant or probationer in this instance of having violated their probation and seeking for the court to reconsider the decision of placing them on probation in the first place. And that's called a petition to revoke probation. Much like when it comes to a complaint or an indictment, the person is still presumed to not have violated their probation, and there is a process that needs to be followed in order for the court to be able to determine that the person has violated their probation and therefore open them up for resentencing. That process is what's called a violation hearing. Now, a defendant can admit to having violated their probation, and they can just do that through putting in an admission, or they can deny it and demand a violation hearing, which is going to be very similar to a trial in that both sides are going to be there. The state's job is to help the probation officer demonstrate that the defendant violated their probation, whereas the defense's side, their job is to try to persuade the court that there is no violation of the probation. These violation hearings are pretty rare because the burden of proof is much lower than proof beyond a reasonable doubt. The only thing the court needs to find is that by a preponderance of the evidence, the person violated their probation. And preponderance of the evidence means that it is more likely than not that they violated probation. It's a pretty low burden. And because there's a probation officer that's saying that the defendant violated their probation, it's a really uphill battle because the word of the probation officer is always going to be more valuable than the word of the defendant, unfortunately. So if it's your word against the probation officer's word, chances are you're going to be found to be in violation. And then the court's likely to treat you more harshly for having gone through the violation hearing rather than admitting to your mistake. And so there is a strong pressure for a probation officer to make the admission to having violated their probation. And if they do, then the judge has all of the same sentencing options that they had originally when they first placed the person on probation. They could sentence the person to jail. They could sentence the person to prison. They could put the person back on probation with increased conditions of probation. So you don't want to have a petition to revoke probation filed against you if you're on probation. It's not a good thing. But if you do, you definitely want to have a lawyer help you deal with that situation.